My name is Diane Jones. I live with you. As the farm in Geauga County that had to fight for 4 years because we were on the wrong side of Ohio Revised Code 519.21. I had to fight for a wind turbine for a farm. I've read, Brady, that you are pro-independent energy. Tell me, what are your beliefs about the U.S. being independent in energy production, given your stand as the opponent in our particular case?
I don't know where you read that.
I read it on your website.
I'd have to go back and check.
That'd be a good idea.
Sure, I will do that. And Diane, as you know, that you did win that appeal.
And let's put it this way.
Sure.
I read about your stand, and I read it as U.S. being independent in energy production. I also recall your stand, for whatever motivation you took, in opposing us as a farm independent of zoning, because we desired to be an independent energy producer as a farm. And those two ideas do not square up with me. I'm waiting for your explanation.
Sure. And as you know, as an assistant prosecuting attorney who represents townships in Geauga County, I was representing the zoning resolution of Auburn Township, which is a legislation.
There was no zoning on the interview.
Well, actually, okay, sure.
But I'm still waiting.
I do believe in an independently free, I wouldn't have to. I do believe in an energy independent country, absolutely. My opposition, I do not have any personal opposition to a wind turbine. I was representing the legislation that was passed in Auburn Township at the time that you were seeking, that your farm was seeking a wind turbine that was not at all promulgated by the Auburn Township zoning resolution, because it was not going to be used originally strictly agricultural. But we can get into the facts of the case maybe some other time, which I know that sometimes, not all the time, all the facts have come out of that case. But as a prosecutor, I was representing the interests of the township with this legislation that was passed by the township. And let's not waste maybe all of these people's time on a personal issue.
Well, we all clearly know that Ohio Revised Code 519.21 does say that farms are independent zoning. I've heard your opinion. This past week, actually, Eugene Rice occasion and telling your opinions on energy in the U.S.
And it sounds like this has been something that's been before the court and obviously before the Court of Appeals as well. And I currently work in the Geauga County Court of Common Pleas. Certainly the concept of independent energy is a good concept and a good goal. As far as getting into the specifics of the case, though, I'm not doing that.
I didn't ask for that comment. Just
sure.
Thank you.
Yeah, I hear people for judges talking about we can't talk about what we believe in certain areas or different things, and that just seems to me totally contrary to what it would mean to be a judge. I ran into one person who was a judge, and they said, "Oh, I'm pro-life, but I can't sign that petition for Ohio personhood because I'm a judge and there might be cases." And it just seems so ridiculous to me. It's like the opposite of what judges are supposed to be. We're supposed to know where a judge stands.
Exactly. That's right.
Those we're voting for. And I can't see that at all, and I'd just like to hear your comment on that.
I can start, as I said before, our job is to listen to the specific facts of the case and then apply the law to that case. By stating opinions, you put yourself in a position where someone can ask to have you recuse yourself from a case because they say that you will be able to be fair because you've already been very vocal about certain opinions and certain beliefs. So, for that reason, we're supposed to remain neutral and impartial and So I guess that's my response.
Right, I would agree that we're supposed to uphold again the integrity, the independence, and the impartiality of the bench if elected.
John,
Well-
way in the back.
Well, just to follow up and agree with what he said, I mean, you say you're supposed to, well, you can't show your opinion because you might be asked to recuse yourself from the case. But obviously, judges like on the Supreme Court have opinions which they hide from us, and then they go ahead and rule according to their opinions rather than the law. So obviously what someone's beliefs are is very important when we want to consider someone
Yes.
who wants our vote. So we want to know where people stand and not have them say, well, I can't state this. We want to know right where you're coming from on everything.
Okay, very good. Matt?
So thanks for being here. You know, the United States Supreme Court for decades and decades said that black people were not persons and not subject to protection of our Constitution. The current Supreme Court says that unborn children are not persons and not subject to protection of our Constitution. And I don't expect you to tell us your views on that, but I will ask you this. If faced with the dilemma of a serious moral conviction that you have personally, and a clear precedent from the court forcing you to rule in a different way, which do you choose, your moral conviction or the legal precedent?
Good question. Good question.
Well, we would take, if elected, we would take oaths to uphold the Constitution, uphold the laws of the state of Ohio, uphold the laws of the nation. It would be a very difficult decision, but I think at the end of the day, you don't necessarily want someone who is going to be an activist and someone who's going to be making law. You do want to, again, uphold the integrity and the independence and the impartiality of the bench by upholding the law. You take an oath to that. So while there might be a personal dilemma, like you mentioned, with respect to personal convictions that are different than what the law says. And again, I'm talking about legislative law, not necessarily judgment law. If elected, I would still uphold the law.
But he was talking about precedents,
That's judgment.
not legislative law. A decision by the judge. Would you go along with that as opposed to your moral conviction? A precedent, not a law.
I don't know.
You know, the Supreme Court of the universe answered that question. It's defined in Acts 5:29. The answer is right there. I guarantee you it's when it's really sound law. Let me ask a question, too. Oh, I'm sorry.
You don't have to go.
I think another option that a judge has is they can accuse themselves. As I said before, we are required to try to avoid putting ourselves in situations where we would have to, but
But then the judge win.
yeah. Well, once again, we take an oath to uphold the law. So you either have to uphold the law, or if you feel that you cannot, or you feel that you cannot be fair, then.
But he didn't say law. He said a precedent from a judgment, not a legislative law. He said a precedent.
We, of course, I mean, we are at the common pleas level, which means we do have to follow certain appellate decisions and what have you. We have to follow the Ohio Supreme Court. That would be, for us, that would be a law that we would be required to follow.
Okay, Ray?
One simple question. You said you cannot be activist if you want that. The last 4 years, activists started to put us to the back record. So where are we supposed to go? You're not going to be activists? We're going to lose. Losing.
I think what I meant by that is that I understand the separation of the three different branches of government. I would not be a judge that is a legislator.
40 years of crap.
Let me ask you a question. If I remember Article 6 of the Constitution, this is where the so-called Supreme Court of the United States say that they get full power and jurisdiction to hand down the decisions and interpret the Constitution. But when I look in there, I don't even see the word Supreme Court in there. What I see is Congress. This is Congress will have the power to interpret. So which way is it?
Good point.
Huh? I I mean, that's what it says, read it. I can read. So it doesn't give them anywhere. That court usurped that power.
Amen.
I think that's called tyranny. How many think that's called tyranny?
Amen.
That's what we have today. Yes, Ken?
Yeah, when the Bible makes a direct statement, we must obey God rather than men. And I think that goes back to what Matt Lynch was talking about there.
That's what I gave in Acts 5:29. That's that set of law that I gave.
Yeah, we must obey God rather than men. Are you willing to break precedent that is wrong and contrary to the directions of the Lord?
Like Judge Roy Moore.
And at the trial court level, that's not our.
When it's clearly obeying God.
My question was simply, what jurisdiction does the court have that you're running for? Because we're getting off on a lot of discussion about the Supreme Court and balance of powers and sort of constitutional issues that I'm assuming are a little bit beyond the scope of a county probate judge or a county police judge. So what are the day-to-day issues that your court will be addressing?
Sure. Civil cases, criminal cases, administrative appeals, domestic cases. Those are the matters that would be before the trial court. Not necessarily constitutional issues. Those would not be before the trial court.
Thank you. Any other questions? Yes.
Bill Lyons, real quick question. Engineer, when you're on engineer, your ears get ruined. Clarification. I'm hearing that you were a magistrate for a certain amount of time, correct? That means you were presiding over a court. Is that right?
That is correct, yes.
Okay. And then if you could explain your experience as such, doing the same thing.
I'm not a magistrate.
You're not a magistrate?
No.
You've never presided over a court?
That's correct.
Okay.
Yes.
That's all I want to know in terms of qualifications.
All right, listen, let's give these ladies a hand.